certain that if I ask you all here this evening to define what public access actually means, I'm bound to get a fairly consistent description. It'll be something along the lines of clients working directly with barristers without involving solicitors. And whilst this is true, I'll put it to you that the very idea of what public access actually means is only now being defined by the various experiences of barristers and their clients on a case-by-case basis. In fact, I'll be bold enough to say that today we simply don't know the full extent of what public access is all about. Now, in exploring the boundaries of public access and identifying the opportunities and limitations it presents, we must anticipate the emerging trends that will define public access in the near future. And if we are to build successful public access practices, we must take active steps to inform ourselves of what is happening in the marketplace and try to accommodate the emerging trends. In the context of where we are today, for most barristers, the decision to accept a public access client is simply made on the basis of whether the client is capable of managing the litigation process themselves. And this is ultimately a reflection on the complexity of the legal case. If the case is too complicated, barristers are obliged to act in the best interests of the client as well as in the best interests of justice. And so, in accordance with Rule C-122 of the BSB Handbook, barristers must refer the client to a solicitor. So what criteria does a barrister look at to determine the complexity of a client's case? Normally, barristers will examine 5 key aspects. The first 3 are the legal, the factual, and the evidentiary integrity of a client's matter. So the barrister will consider the extent to which the client understands the facts and the law. Last but not least, the barrister will assess the client's capacity to pay their legal costs. And given that I represent legal cost finance, which of these aspects do you think I'll consider as being the most important? Of course, I'm going to tell you that the client's payment capacity is arguably the most important element, as it can be extremely challenging indeed to run a case without funding. However, I'm not going to spend too much time on the subject of legal cost finance because I have other goodies to talk to you about. But I will briefly say that in the context of direct public access, you'll find that clients are much more receptive to paying their legal costs by way of small installments over longer periods than by paying large amounts up front. Now, I'll ask you to note here that I'm not talking about classic litigation funding. I am in fact referring to a tailored consumer finance solution for the direct access market. And the solution simply involves legal cost finance providing a line of credit to public access clients. And this enables your ongoing and future fees to be immediately secured in barcode, and at the same time, this makes the cost of your professional services more affordable and convenient to your clients. So how do you offer public access clients the option of paying your fees by installments over an extended period? It's actually very easy. You simply give them a payment card from Legal Cost Finance. And you can place the cards in a special stand in your reception areas, and you can also send the cards directly to your clients with your next bill or cost estimate. By the way, barristers are exempt from FCA regulation when offering consumer credit solutions. This is subject to Part 20 of the Financial Services and Markets Act 2000. Legal Cost Finance can also white label the cards for you, which we have already done for numerous chambers. So your chambers can have their own proprietary payment cards and offer them to your public access clients if this is preferable. So I'd like to go back now to the topic of assessing public access cases. And I'm sure you'll all agree that straightforward cases can be identified relatively quickly. In fact, many barristers believe that these cases are exactly what public access is all about. And in fact, there's nothing wrong with building a public access practice on the basis of straightforward cases alone. But from a client's point of view, the purpose of public access can actually seem quite different. For many clients, the more complex a legal case is, the more reason to seek a direct access barrister. And the sole objective for the client, of course, is the elimination of solicitors' costs. And here we come to a sort of crossroads, which really starts to define the meaning and limits of direct public access. On the one hand, public access is designed to make legal services less expensive by eliminating the cost of solicitors. But on the other hand, the very act of doing away with the kind of support that solicitors provide can actually disqualify a case from public access eligibility. So the key question is to determine that pivotal line when the case shifts from qualifying for public access to one that absolutely relies on the involvement of external legal support. And here I will return to my earlier point that public access is still being defined, because that critical line, the threshold that qualifies a client for direct public access, can in fact be somewhat blurred, depending on a number of factors. The first factor is whether the barrister is actually authorised to conduct litigation. For these barristers, the threshold that qualifies clients for direct public access is much lower than for barristers who are not authorised. And that is because barristers who are authorised to conduct litigation have the necessary case management and document management systems to accommodate more complex systems without the help of solicitors. The second factor is whether the barrister who is not authorised to conduct litigation relies on some form of paralegal support. Clearly, a barrister who employs paralegal assistance can manage a larger and more complex workload as compared to those who don't take advantage of this resource. And there are numerous paralegal firms that specialise in assisting direct access barristers already operating in the market. The third and final factor is whether the client is relying on paralegal support to help with the litigation process. Once again, there are numerous specialist paralegal firms that offer clients assistance with litigation conduct, and this enables clients to avoid much greater cost of using solicitors. Now, because paralegal firms don't provide legal advice, they can avoid the cost of regulatory compliance, as well as expensive professional indemnity insurance. Therefore, their hourly rates are usually much lower than that of solicitors. In fact, they can be as low as £50 an hour, whilst providing quite a sophisticated level of legal assistance. Now, paralegal firms can provide a lot of support for clients, for example, bundling, drafting, assistance with filing, arranging witness statements, providing clients with general litigation legal information, explaining the legal process, and generally assisting clients in managing their litigation. Now, I have a question. As a matter of interest, how many barristers here regularly rely on paralegal resources and support for their own practices? Is it possible to just have a show of hands? Okay, so 2. It's interesting. Okay. Right. So let's consider a situation where a client turns up at chambers and it is not immediately clear how much support their case needs. What is clear, however, is that they have a genuine grievance and a box full of documents. And to decide on whether this case qualifies under the public access rules, you may need to invest considerable time in understanding the complexity of the client's matter. And this is often exacerbated by the fact that the client doesn't have a good understanding of the legal issues involved, or that the client is unclear about the facts and potentially has 5 more boxes of unsorted documents seeking home. For many barristers, this is exactly the type of client that would need to be referred to a solicitor. But of course, that would defeat the client's cost-saving objectives and certainly defeat the purpose of public access. So in dealing with a potentially complicated public access case, there is a need to fill some voids that are created when we eliminate the supporting role of solicitors. In fact, the very first obstacle that barristers encounter is actually the disadvantage of not having a detailed brief about the client's case. And these briefs, which solicitors would normally supply, enable barristers to quickly assess the factual, legal and evidentiary integrity of a client's case not to mention the ability to assess the client's capacity to pay their legal costs. Without the solicitor's brief, someone else must test the merits of the client's case and gauge if a client pre-qualifies for public access. Presumably, this function is currently performed by either the clerk or the barrister directly. The problem is that clerks are not usually qualified to perform a comprehensive legal analysis. And even if they were, clerks don't often have the spare time to perform this highly responsible function. Don't forget that clerks already have the added burden of dealing with public access clients and trying to secure their instructions. But what currently happens is that clerks try to identify the basic parameters of a client's case, such as the area of law and the key legal issues, and then simply hand over the client to a suitable public access barrister. The barrister will then perform the comprehensive case assessment themselves, often spending considerable time on the initial case evaluation, including conference with the client, and possibly without really being able to charge a fee. Now, if it transpires that the client's case is insufficiently formulated, legally or factually, barristers may advise the client to go back, review their facts, bundle their documents, prepare their evidence, and do a lot of the groundwork that solicitors would have done for them. And this is in fact the essence of public access, clients doing the work themselves, instead of relying on solicitors. But quite often, when clients realize this, they simply don't come back. In these instances, clients can slip through your public access fingers, so to speak. But it doesn't have to be this way. And the good news is that by understanding the importance of a solicitor's brief and emulating its function, we can actually assist clients in the pre-instruction phase. And by doing so, we can secure instructions much more effectively, even with complicated or badly formulated cases. So let's imagine that there is a way to generate a solicitor's brief without investing the clerk's or barrister's time and without exposing the client to solicitor's costs. Enter an online solution that enables clients to independently generate their own briefs for barristers, highlighting the factual, legal, and evidentiary integrity of a client's matter. Legal Cost Finance has created an extension of its website called Public Access Legal Support, which has an acronym of PALS. And while assessing the client's capacity to pay their legal fees, PALS uses sophisticated algorithms to convert the information obtained from clients' financing applications into detailed case consideration briefs. The process starts by clients simply completing a short questionnaire as part of the legal cost finance application. Sophisticated algorithms in conjunction with some human processing are used to convert the client's responses into detailed case assessment documents. We call these documents client pre-qualification briefs, or simply PQ briefs. As you can see, the algorithms identify the key parameters of the client's case, that is the factual, the legal, and the evidentiary integrity, as well as the client's payment capacity. The PQ briefs immediately provide barristers with a comprehensive profile of a client's case, enabling the barrister to quickly identify its strengths and weaknesses and see whether the client qualifies for direct public access. Here is an example of what a PQ brief looks like. And as you can see, apart from identifying the basic parameters of a legal case, it represents these parameters in a graph, which enables barristers to easily gauge factual, legal, and evidentiary aspects of the matter, as well as the client's payment capacity. There is also a line running through the center of the graph, which represents the threshold for public access qualification. As a result, it is very easy for barristers to see which aspects of the case fail to qualify and what needs to be done in order to rectify this problem. These could be minor issues, such as simple document bundling, or more complicated obstacles such as time limitations or jurisdictional concerns. The assessment criteria for generating a PQ brief is actually quite detailed and legally sophisticated. But the initial questionnaire that is used to obtain information about a client's case is carefully designed to to ensure that clients have a very user-friendly experience. Now, once the barrister accepts the client's case, Legal Cost Finance, through its PAL service, can also arrange for ongoing paralegal support and provide an online forum for communication between the client and the barrister. PALs can white label this solution to protect any client ownership concerns that chambers may have. That is, that clients can generate their briefs directly from your chamber's website. And most importantly, the PAL solution, which is offered by Legal Cost Finance, is entirely free of charge to chambers and clients. So what is interesting is that PQ briefs not only save time and resources to process incoming public access inquiries, but the novelty of this online service is actually helping chambers to attract new clients. In other words, if you engage a client in creating something that helps them to identify the key legal and factual parameters of their case, the client is simply not going to go anywhere else. They will be committed to stay with your chambers. In fact, the PAL solution is currently delivering a high rate of success for those chambers who are using it right now. So in conclusion, I will again return to my earlier point and say that the boundaries of public access are still being defined by the various experiences of barristers, clerks and chambers. However, I strongly believe that successful public access practices will be the ones that recognize and adopt the emerging solutions in the legal market. These solutions can have a profound effect on your future success and on direct public access as a whole. I will sincerely recommend that you keep in step with these developments and wish you all the best of luck in your public access endeavours. Thank you very much.